And the ruling of the court, which is found in 2013 Supreme Court of Ghana Law Reports at page, the special edition, at page 61 onwards. The ruling of the court states clearly why the lordships on that occasion did not grant the application. And I would respectfully refer to a passage at page 71 of the judgment of the ruling read by the Ladyship Sophia Adinua. And she says as follows: in the circumstances, we hold that the petitioners are sufficiently and well informed about the election results, which had enabled this petition on grounds of practices in 4,709 polling stations, based on the contents of these duplicate documents in their possession. In that case, the petitioners mounted the petition on the grounds of 20 categories, as they put it, of malpractice in initially 4,709 polling stations. It became 11,000 by virtue of subsequent amendments, 11,000 and more. And so what the court was there saying is that the petitioners themselves have already put forward in support of their case documents that they had confidence in them forward. And therefore, to ask to inspect documents when you yourself have said, we're putting these forward and this is the basis of our case, that is contradictory. In this petition, my lords, we have not put forward results or malpractices in 4,709 polling stations. In this petition, we have put forward the words of the declaration of the chairperson, the returning officer, the only constitutionally mandated body, or person, I should say, only constitutionally mandated person to exercise that responsibility. And so clearly, the rationale, the ratio decidendi of that case cannot relate to what we are dealing with in this petition. And her ladyship goes on to say that the affidavit in support of the application does not disclose any need for the inspection of copies of the originals of the documents. My lord, nobody can say that in this case we are not disclosing any need for the inspection in a situation where we have changing numbers, in a situation where to this day we are in no place to state a definitive number. In those terms, in our respectful submission, it is actually even in the interest of first respondents, in terms of transparency, in terms of fairness, it is actually in their interest to make available. That is why, frankly, we did not expect that we have to make this application before that request is granted. We honestly thought that this was something that would be resolved and we would go and have the opportunity to inspect there are conditions in the rules of court within reasonable time and within reasonable circumstances, and we cannot obviously flout those circumstances. So this is something that could have been resolved, very straightforward manner by enabling that inspection to take place without having recourse to order of the court. But not had even the courtesy of an acknowledgement of our request, and therefore we are obliged to seek the orders of the court in order that we can achieve what will enable us to have a fair hearing of the petition that we brought. If there's nothing to hide of transparency around these originals, it's difficult to appreciate why an inspection could not have been granted because of the last 14 days or so since we filed. 12 days to the end of January, so about 15 days. If there's nothing, if the interest of the first president is transparency, as has been indicated, then why would it be so difficult? Why would it be so difficult to allow access to the originals? We haven't come relying on our duplicates saying that they are the basis of our case. We've come relying on her own declaration. Her own declaration speaks for itself. So, my lords, in this situation, we require access to the originals, which we can compare with what we have and try to get to the bottom of these ever-changing numbers. That I made to a fair hearing is also anchored because we are saying effectively that this access to these documents is required for a fair hearing in this case. It's not within the province of the first respondent to pick and choose and the way they sought to do in on. It's not within their province to pick and choose. So this document which you have, it didn't include Ayenswanu. There's nothing on the face of the document which says Ayenswanu is there or not there. Nothing. This one which you also have, which is supposedly about the same regional result, regional collation, that document has different numbers. And we just have to take it from them that Ayenswanu's 40,000 is what has led to the difference. But that is totally unacceptable. The greatest respect. And Article 19, 13 of the Constitution makes it is required to give a fair hearing within a reasonable time. With your permission, read that article. And adjudicating authority for the determination of the existence of the civil shall, subject to the provisions of this Constitution, be established by law and shall be independent and impartial. And where proceedings for determination are instituted by a an adjudicating authority, the case shall be given a fair hearing within a reasonable time. Now, as I indicated, we are asking for a fair hearing of the petition that we have brought. For that fair hearing, we are submitting that the matters that we have, the documents that we have sought are necessary documents in order to understand the case that is being put against us, with all its changes and permutations. And so it's our respectful submission. And my Lord, I may just make a comment finally on 6. In 6, that is not dealing with originals. That is dealing with records of the alleged update to the purported declaration. Now, my Lord will observe that update exhibited W1's witness statement. That update is not signed by anybody. It's a press release, and we do know. That update not signed by the chairperson. It is not signed by anybody. And we do know, my lords, that the constitutional role that is assigned to the chairperson, both under the Constitution and under CI 127, that role cannot be delegated either to a media relations officer or to a deputy or any other. It cannot simply be delegated. And therefore, how the record relates to that update are things that need to be inspected, particularly when we have pointed out to your lordships that in that update itself, certain are put there which are different from what we all heard in the declaration. So some records are required. There must be some basis internally for alleged update, and that's the essence of what is in paragraph 6, 1 to 5. It's our respectful submission, therefore, that in the interests of justice, this application be granted. And I will also just conclude what is provided in Order 1.2 of CI 47, that these rules shall be interpreted and applied to achieve speedy and effective justice and ensure that as far as possible, all matters in dispute between the parties may be completely, effectively, finally determined, and multiplicity of proceedings concerning any matters avoided. Indeed, this proceeding, in our view, is really quite unnecessary because it could have been dealt with expeditiously. I omitted one point in their response that I just want to comment on in one sense. Both responses begin to raise issues about burden of proof in the case and so on. In our respectful submission, issues of burden of proof are irrelevant to the inspection of documents. The burden of proof in this matter is something on which no doubt we'll have occasion to address on different aspects. Whether the burden of proof is on us to do this or that, those are matters that at the appropriate time we'll deal with. But affidavits, essentially, they are laying claim to some view of proof which is legally very suspect. But on that basis, they are saying that this application should not be granted. For that.
You refer to line 1. Can we take a look at order? No, you refer to order 21 rule 9. Can we look at order 21 rule 11? And if we are on it, since I believe the primary objective of this application is to determine the total valid votes. That's is to determine the total valid vote. No.
I'm sorry. Yeah. My lords, this application is not just the determination of the total valid votes cast, because the total valid votes cast goes back to whatever was happening at the regional coalition from 12, that is evidence that there was some dispute about that. So it's not just the total, it's also to do with the allocation of the votes. You'll also in the Exhibit D attachment that we have, there are differences in allocations of the votes cast. So it cannot just be in respect of total valid votes cast. It cannot just be.
Yeah, can you look at Rule 11? Rule 11, sub Rule 1. 11.
Rule 11. Production to be ordered only if necessary. Yes. For the production of any document for inspection or to the court shall not be made under these rules unless the court is of opinion that the order is necessary either to dispose fairly of the cause of matter or to save costs. And then where on an application under this order for production of a document for inspection or to the court, privilege from the production is claimed or objection is made to the production on any other ground, the court may inspect the document to decide whether the claim or objection is justified. I don't believe that privilege is an issue here.
Reference 1.
Yes. And 1, we have addressed you on the necessity. And we have addressed you by referring simply to the attachment to Exhibit D, which has been the basis of a lot of cross-examination here, and the basis of a lot of explanation from counsel. But that Exhibit D itself, in our respectful submission, shows the necessity for knowing what is the original document on the basis of which we must choose one or the other. What is the original? That is my submission.
Let us. Question: when you take them, what will you be doing?
Well, we'll be comparing them with documents that we have, which we regard as authentic, to see whether indeed they are the same. That's what we'll be doing.
But you don't see the need to tell us what you have as your valid vote?
No, we do not have the need, because we are not the returning officer, with the greatest respect. We are not the returning officer. And my lords, with the greatest respect, this is quite an important point, because Lordship Justice Apao did ask certain questions in relation to PW1, and in our respectful submission, those questions are completely irrelevant to the issues that have been dealt with, because the question whether he has documents.
My lords, if I may be heard on this. My lords, I think counsel should argue the application before he... Yeah, the question had said.
Let me answer myself. Mr. Chikata, please, your opinion. So keep it to yourself.
Yeah,
Whether the questions I asked were irrelevant or not, that is your opinion.
Yeah, but my lord, I need to explain why I'm saying they're irrelevant, so that I can fully answer the question. Because the question relates to the same position that your lordship took. The question relates to that. So I need to on why I say that they're irrelevant, because I don't say that lightly. I do not say that lightly. I do not say that lightly. The questions are irrelevant because we have brought a petition here on the grounds of a declaration purportedly about elections held on the 7th of December. The declaration stated a figure. We all heard it. 14,300 and 400 and all. We all heard it. That declaration to this day is the only declaration that has been made. Johnson has seen is not representing of the election of 7th December. That is all.
This is Angel 102.9. This is Angel 102.9.
We are opposed to this application. And my lords, we rely on all the depositions in the affidavit in opposition. My lords, under Article 64(1) of the 1992 Constitution, the petitioner has had 20 days the date of the declaration of this petition. Lord, into this court that between the time of the declaration and the time the petition was filed, any such request. Lord, secondly, the question is asked, why is this application being made on the 34th day after the petition has been filed, when hearing is well underway? Lord, if you peruse exhibit, the document filed to give the first respondent 3 days from the date of sale. Lords, with the greatest respect, there is no such rule of this court under which this application was made, or even the High Court rules. Yes, but it talks about 14 days. Mutual discovery of 14 days, my lords. Lords, because rules, rule 5 of your rules. Oh, sorry, my lord, rules of the Supreme Court rules. With your kind permission, you may read. Where provision is not expressly made by these rules regarding the practice and procedure which shall apply to a cause or matter before the court shall prescribe the practice and procedure that, in the opinion of the court, the justice of the cause or matter. Laws have been several reasons on this point that it is that you make an application to this matter. Laws, with respect, if I may tell you to a case of Ghana Limited number 2 versus Atie number 2, 2003-2004, Supreme Court of Ghana Law Report at page 75. Respect, Adre DSC, speaking for the court, said this, and with your permission, if I may quote it. I hold a view that the application before us cannot be entertained under Rule 5. My opinion, where a party has difficulty or is in doubt at steps to take, where there are no expressions of procedure provided, the party apply to the court rather than, and this is my practice, rather than arrogate to the power given to the court under Rule 5.
Yeah, these are Amenuvo.
Yes, my lord.
You see, he came under mutual discovery. That is order 21. Yeah. When you look at the proceedings, we've gone beyond that. There's no response from you. And when you allow inspection of documents, then you can respond 29. And this is the application you are determining. Look at the previous case again, whether you can look at Rule 5 of the CIC and apply.
So my in order to make the point of the timing of this application. Yes, my lords. The timing of this application
After the failure of mutual discovery.
My lords, proceeding.
No. Respond to the question. What I'm saying
Yes,
is mutual discovery. Do you have any time frame set down that order 21?
No, my lord, you have to apply to the court.
Yeah, and this is the application you are determining.
Yes, my lord. So the point is that the greatest respect, the point is that where CI 99, by which the presidential election petition talks about timelessness, then when you make an application at a particular point in time, responding to the application, with respect to the court, we are entitled to make the point as to the timely nature of the application. But the second point I wish to make is that the petitioner has failed to prove the production inspection by the first respondent is necessary in these circumstances. This is because the witnesses themselves who came to testify on behalf of the petitioner themselves admit that they have the documents. And the way this process is that once the document is filled out, or the agents are given the carbonized copies, and we did ask them, both of them, that do you have the documents? They said under oath that we do have the documents. So therefore, if you do have the documents, on what basis is this application being made? My lords, it's our submission that the situation is that the petitioner has failed to provide any evidence in support of the petition. And that is why at the end of the cross-examination of the petition, this application will be brought in order to give them the opportunity to lead further evidence. I do not believe that it has been the practice of our courts that evidence is led in piecemeal. Evidence cannot be led in piecemeal before the High Court, how much the Supreme Court. So it is our submission that for these grounds, and of course, the burden to provide sufficiently for the if they have it, and how you feel to do that, they cannot at this late hour come and make this application for documents which the witnesses themselves admit their possession. That is our submission.
My Lord, at the heart of this application, the question of which party the burden and the burden of evidence. My Lord, I say so because the petitioner, by witnesses and by law, has photocopied all carbonized copies of all the processes from the police to the original level, and then even to coalition to carbonized copies. Therefore, where the petitioner raises a question about the authenticity of any document, he must first produce what he has. What he has is different from what the other party has. It is in respect of the petitioner has all the documents that will enable him sum up the results, the national results of all the candidates. He has the carbonized copies of relevant documents that will enable him to sum up the total number of votes he got, the total number of votes the second report got, and the total number of votes the other candidates have. My Lord, the petitioner to himself refused to present before the court. He bears the burden of proof. He has refused to take any steps to meet that burden. He has refused to produce any documents to meet his burden of producing documents. Then he turns around and under the guise of application to produce evidence, they say he's trying to garner the evidence that he used to prosecute this case. My Lord, this is a totally misconceived procedure. My Lord, let me say again that it is not as if the petitioner that from the documents I have, the documents that the EC is producing is not the right document. Therefore, original, because the exact carbonized copy of what the EC has is what we have. He's not saying that. Rather, application confuses authenticity because you are questioning the photocopy as not the original, the carbonized copy as not the original. And where the document is authentic, but you are issue with if the document is authentic, you are taking issue with the content, you have a problem with it. It's a different matter from that it is authentic. You can only make the question of authenticity if you have some showing that this cannot be the authentic document, and say that nobody can quarrel with the petitioner, where he says that I have problems with the content of the document, produce the carbonized copies which will show that the contents of the document are wrong. And that is why at the heart of this application of producing evidence onto the result, and that is never possible in any law. Again, we wish to make it very clear that it is not the number of times that council refers to transparency that would make the case that not transparent. He needs to provide evidence and not as a statement about transparency, repeating it over and over again. Then again, my lords, the petitioner makes a very curious statement about fair hearing. My understanding of his submission is that he's using fair hearing to conjure away the burden of proof. Conjure away. He's using the right of fair hearing to
This is Angel 102.9. This is Angel 102.9.
My lords, to your lordship, with all due respect, I think, my lords, with due respect, the application seeks the right to fair hearing to conjure away the burden of proof and the burden of persuasion. These are very fundamental issues in a trial process. He cannot shift the burden of proof, not let any evidence compels us to give evidence in response. He has not evidence, much more that is all the time on him. So, my lord, if this is the reason for his application, it is a misconceived application. My lord, what makes it worse is he has not met the basic conditions set out in order 21 to 11. 1. 21 Rule 11 1. Level 1 of CI 47, which reads the definition as follows: an order for the production of any document for inspection or to the court to be made under any of these rules, unless the court is of the opinion that the order is necessary, either of the cause or matter. My lords, it's a conviction that the council has not shown any way whatsoever the necessity of this. Furthermore, he has not demonstrated how this will aid the fair of the application save costs. It will not help save costs because indeed, if the application is granted, I'd rather increase the cost of litigation. It will not promote a disposal of this petition because it is misconceived. Being misconceived disposal cost of money. Council, when he referred to the decision in 2013, where 70 thereof so far made up and a guiding principle, page 70, my lord. Council was right, but he was completely wrong. An interpretation is on the text. The text. In the instant application, an application of documents of inspection of the or to say now the court observes the result correlation forms and the declaration forms are public records, official custody of second response electoral commission. The petitioner has responsibility like all other independent 2012 election. Copies of the same documents through their and collation centers, so-called strong room of the Electoral Commission in accordance with the Public Election Commission. It is a of a copy of the document that parties it is unnecessary to apply or for the court to make an order for the inspection and making copies of the document in question. The court makes a very important point. Of the Evidence Act 1975, 166, the duplicate of these to the same extent in the custody of the respondent. That's the now the court continues. Petitioners have not raised any concerns about the copies given them at the collation center. Those concerns before your lordship. This application
to indicate the effect of point. May I that is what we have before we ask for something. There's nothing in Order 21 that...
My lords, that's not what I said. It
That was. And nice copies exactly the problem. We've indicated with examples that we are confronted with a situation which needs to be clarified.
My lords, he can only respond on legal issues. Please.
This is Angel 102.9. This is
Ombana se ombeji tuma ombe kachre yi ombe na so ade achre yi na terms no yeah share quickly let me just even though for the camera Jose ebia da bit that's how we now know Eddie free so diabetes etete wo hwa na we mu na hwe hwa woni so ayo kusukusu kakrakra wo wa wonom ebepo adogono laptop hwa na officer 24906 yebeje wo so and Sons Farms Limited at the Boys Olive at the Aba any Borges we are chiche bebre the Borges Classic Borges with which made the yes to be near say apple cider vinegar and only there a pure organic unfiltrated a tablespoon cow more you do no say I know Abba said that says stroke and so when you be a beboa. Your number is 0543 158195. Na fe yetme aje wo so dodo. And no eda and chaya. Fanos garlic capsules no so pacho we no extra intine when you be no ma na twena ko fam kakra na normal so dan check na no edia fano and ye pa share so family fanos so be a very excellent food supplement then so 244 na nje so app so away yes kan kwa na e besian kwa na de app wo ko store ana app what downloaded it so every 200,000 yeah the amount was for valid ID card, say voters and a passport and any other valid ID card or memo ha yetimi ejitumo na fe eno echi no so no wo MTN Momo wala phone so put them straight with and what dial 7 star 4 hash na ana wo krono and then chat next cafe yeah nebu nyedin we wow to boss ya was on what so very sweet and creamy. Aroma no very tantalizing. Ended that war. What me only one Ghana city. So we try the new Nescafe. No, Shannon starts with a Nescafe Chama bi o.
Me be ma e wadwuma bi wo ho se apai ma omomo pa adwuma enti mesre se uti
ni ya be fire
se na say no ya ntimi anya enti se bosso ba ko sa bosso ba ko me ma telephone number no fasisi a me mfre telephone number se eye me ho ba ko pe achini 0241
baba ko ka
okay 0241 7 000 0241 70074 05 50 059 50 263. Now a security men, factory, supermarket attendant, drivers, house helps, marketers, waitress or waiters, receptionist, caterer or cook, shop attendant, cleaner, chef, warehouse attendants, office assistants, supervisors, manager, and I think so more attendant. And to when you decide, you might boss will be a telephone number 700 near me and 70004 and I 502363.
Next level, come go so your nyanya. Next level energy drinks. I bring who here so turn nakem. Hey, I didn't grab short. Who pay be ground, and the body is I come and the minimum say you're not the abema what's in the day. Pano no back when so I do my breath say breya or more control first respondent Juma we net na ye kwetenti aye hwe bi ye Juma small job breast ya no bia e wu nyanko na be hu fa so no se be ma wa ye me na ka da no kwa tanko ka wa ha se
ya chabe
Juma be ma wa bonasem ketwa
kwa me tanko so na kan sa
akwati katelo wa se
the full so
ya numbi enu kra de na ebe bua don ko na so for the we ya na papa fako
o se be media
sisi a we twa
enti na no ya kwa certificate back semester da odom accident sie ama odom pemu akuruche bubuo na opesa ye boa na yakeka sie ani ma wo meye ho adwuma ma fertility stroke ibie emu yade ni ade na korowa no sutu na mountain o ma cha kwan stroke na gonorrhea no problem akwa omo papa onu ngwa area mu a na spend baby e dance Wama tambula COVID ya be ya ene sha me bra me bre kura na na se the president aka na force wa person the force na homto wa na bi se the be a so abetimi a se bi ha de spray ho nti gabetimi ayi na me sha mo ho se ma ye sha no ye ha dwene ti to me e sha wo de ho na ha nya ambulance o mo betimi to hospital na to me abua from 0243983906 0243983906 Greenfield Scientific Care Bank no yeah fam was a kafam lovey promo kafam lovey promo omo ma dey tutu America na kafam o be boa yie want to be more wa boa wa go ya for microwave home theaters bless rice cookers etc. I don't know near woman no cranya some etc. Come up and Coco Pet Cafe for discount 60 how much 60 in the discount famo ye can ye if you want to show and as a discount engineer or drop more don't lovey promo near the brewo and to Jack and then for one on your papa I love you now the one and Mami na te kwa. But what do you no? Sa sopra so price will get Monya the both 80 no from 050 00 00 105 050 00 00 105 come from the one makra kewu but what the
60% be one papa but say ya dey be na how
say mama page mama me technician we school now na fear sa so why asabia be a lab test now what frame me the me ala so all the make and to me for 28 it impose 4486 and your lab adwuma Mr. Ofremi medwa papa
Domino Herbal Center semen kanchro engine won kokko omo de nura na be san so sai de wa ahodo omo de ba Domino Herbal powder sa powder diabetes na how stroke but related disease high blood pressure heart related disease tiredness will be your time Angel Domino Herbal Center ewo nkoko hono no from number ta heba esayaresa kese pan to betimi akje wa yaresa friend telephone 0243 158 195 0543 158 195 sanso so na omunro eye powder no ko eye nkran so kan she drug lane ebi above all storms herb ebi wo ho ohima just e will be tema ye wona na community 1 our community 5 pharmacy Kofodia pharmacy and Henana pharmacy so ebi o Henana hono ebe ye ewo Kofodia so obeko Angel Dominion Herbal Center Dominion Herbal ebi na eni wakagine mom sanso so na Springfield technology where ye kan ho asem no computer ni hum sem ni software ni hardware ni say computer na dey bibi so we be a we computer mu dey na and me kan for e dey am Springfield technology yeah more programs are more introducing to computer software database administration system administration web development working administration developments app yeah ebe fair kwan strong so almost also voice coaching keyboard lessons and a guitar lesson open kwada wo if you know some music ni ada wa free telephone number 0244 60 hands teacher be yes like when yeah
wo
Bia now pray to me is any money it's office infected yeah and me pa sure Bob, so that me who and we about what was through BT. No, obi wɔ anya ho court I say yeah. So na everybody so na you know rough they kind rough well God yeah someone Emma and some no my judge yeah krawan lawyer both NP we are near the ba ko aye
Fan say one point natural mo ko me na bi ya page am na ni nyina na person you already this say na mo dia enenti ni bi la petam mo ede enwa and so adan many for high for high court. Yes, say a bit based say way it's 20 Supreme Court mobile na chachu lawyer yeah court and to yenim dia fanka yeah dance and for once one of from so almost for you hammer dance for dance where the kind and I said only lawyer so argument when you and from achievement no ebisa lawyer also you're not So, papa papa no who is na from almost say how much yeah this who are banning see me one see a 433 na and so na ya suit you tra suit said the of any suit black just suit up side of and then and so the begin in aduke na die power enyi ni se ni kunu oni pensa for now now this is more any say yeah come on church no. Bi o kwan yes dance ko say
ne ade observe article to ya aye Supreme Court to my so far man say and time on my and nature moment I said two on application and say bachelor when decide if electoral fear the man power now senior figure me of
say the matter yes is it for
Nti sisi any kesi kwa ba
jodo
ya no
court
brofo. Yeah. Ofi bebe. Yo. Ma. Motion. Motion. To be a point now na the winners already it's the point yanka me to my there documenting import them
a lot near my try and then I'll start beside times so doc but intense
Surah advert yeah my I mean first naturally them doctors to complete in our feet and you made that
charge in
set and that more like that issue question that evidence that some and so we did and arrest
will be just Ben demanding aqua
any election your photocopy pressure. I don't know what them, but original copies. No. Kufa lawyers do one copy. Kind of original copies. NPP around it's it's my show. I mean another way. That's all. Already. Or cross evidence copy when it or copy back for the confirm
Okay.
Oh, but man, show. You who the come on. Okay. A request inspect then had the order for them for
Obey. Yeah.
yeah.
No.
Mahama no watch them to court
to the document. And that
Supreme Court people yeah. There's no need there. Okay. This is unconstitutional. What is the job?
No, none. Yes.
Be the way more case another with me. Into some of but me maybe beside same Nankasa. There's one court some beyond me who the view. So what I mean down home or someone some or small part BB and
than some.
Coming. Use
Okay.
don't put a video say back it's a man for the video listen
was to why yes him there to what on it cannot why
my what take do it to know my drink on so you know
what would what explain what and colleague I mean if he said no was that oh them the parents some of both that oh sorry
no has a point. Case now internet when you prejudicial okay issue
Yani credit and so almost we this for Toyota yana interest ɛwɔ hɔ secretary save no wa abusi for yeah
I mean I knew when I got when I read
Scott come on. Sign for potential. Sir, just name.
reason
oh
now some more now so nkasa e one ipana example remember as some American nature straight through you we've seen okay. Through the white. No. Most
judges friend
on your issue. Zame yo betisi. With is but no one so my document from Pamu. I don't is about home of them.
Possibility of then the mark be
Evaluate natural do not so that I did judgment. You had so work decision. Madu
I want to sitting day. Now, all church experience.
The maximum we input
I could say so the food position here
court nipa say only kasa yana ya going to of can fire in a ticket trouble
I don't know for the judge now. What can
Canada. Into opportunity. You as
it's not
So you some
Kasano. On you ever. So then
is really resident so I can before be baby is that on and
is that bro control anyhow new people
after that is game Lego PSC today. Right. No.
And hold on. To lawyers at you are in do some
BBC oh example judge no be a transfer
Oh, usually so only for one last super
now ma yeah I think after the and yeah Gimpa Gimpa
okay. Is it of course going to grab a
is uh
okay. Yes. In fact, sir,
most
me I say it's I'm yeah or some declaration But it's your is that the declaration
country when they like almost specific that is up but forever uh 50 3 years.
What is it based on? Captain Smart, but this
If you are beginning one
certificate
okay.
But
one so it's not young into for you.
Yes. Yes.
in 27
Hear them.
And I'm coffee and
asking the best thing do I have to do?
yeah, was it? Kenya kwa kwa nko sitasa tan
Kedomam. 3
Okay.
Season.
Now,
lines in at all or no nya kade
I say one as well. Two. Menyan. Kokot neighbor.
What time?
No.
More cases as I've gone. Long I can't around. Fine.
Was it?
I said, and then.
No, really, we are execution rubber burden, and maybe I knew the application called court in there. Where you might say, into one more kind of good turn in kakra. Maybe more haban be or make crass and marry by
all right.
Enti court number. Clerks na microphone this is here.
Enti say you be say you be attach cut application the two no agree no.
This application requires access to inspect the originals of listed documents which were earlier served on the first respondent by way of mutual discovery under Order 21 Rule 1 of CI 47. The documents under consideration are required under CI 127, that is Public Elections Regulations 2020, to be given to every candidate who participated in the presidential elections through their accredited agents. Indeed, Regulation 44 of CIA 127 from sub-rule 7 to 11 inclusive sets out the different forms to be completed at the various stages of the electoral process and copies of same given to the accredited agents of each candidate. The applicant has not demonstrated that he has no copies of the documents in question. In fact, on record, PW and PW2 have admitted on note that the petitioner has copies of all the documents. The application for discovery and inspection requires the discretion of the court. The guiding principle is that in all cases in which a court makes an order for discovery, it is a matter of discretion and not as of right. In the ordinary way, where there are issues of facts between the parties, the court will generally make such an order. However, in the instant case, the applicant has not raised any issue that he has no copies of the documents of the subject of this application. In view of the fact that the proceedings so far shows the petitioner has copies of all the documents, the subject of this application, we are of the opinion that no proper case has been made before us to warrant the exercise of our discretion in favor of the applicant. Order 21 Rule 9 of CI 47, which is the basis of this application, should not be read in isolation. It should be read in conjunction with Rule 11 of the said order. It states thus: an order for the production of any document for inspection or to the court shall not be made under any of these rules unless the court is of opinion that the order is necessary either to dispose fairly the cause or matter or to save cost. End of quote. Furthermore, Section 166 of the Evidence Act NRCD 323 of 1975 makes it clear that a duplicate of a document is admissible to the same extent as the original unless a genuine question is raised as to authenticity of the original of the duplicate. No issue has been raised against the authenticity of the duplicates in possession of the applicant. The discrepancies which learned counsel for the petitioner has alluded to in his submissions as having occurred in the declaration of 9th December 2020, the press release of 10th December 2020, and the answer and witness statement of the first respondent are issues of evidence and do not give cause for discovery of the documents under consideration. From the above reasons, the application is dismissed.
As the court pleases. We are grateful to the court.
My lords, we are most grateful.
My lords, there is a matter in respect of a health situation affecting a potential witness, which we have indicated to my learned friends on the other side, we would like to have considered by your lordships in camera, if it is possible, because of the confidentiality concerns. And we would be able to provide some details to your lordships accordingly, if that is permissible to your lordships.
Counsel, did he provide any witness statement on record?
My lord, in fact, the non-provision of a witness statement itself will be explained.
Oh, please, it's a court of record.
Yes, my lord, that is why I said that the circumstances relate to a health situation which have made it impossible to get a witness statement as at now, as we speak. We have been in touch not only with the potential witness but with his medical, and that's why I said that because of the confidentiality, if you allow us to grant you full information then you may exercise your discretion as you wish to direct us, and we can proceed accordingly. We're not, if your lordships will not entertain the matter, we will abide by your powers. Let me be clear that what we agreed is that we would put it before you in detail in chambers. Not, we have not, yes, that's it.
102.9. This is Angel 102.9. This is Ghana's own Angel 102.9.
Yes, my lord.
Yes, my lords, exactly what the situation is that this morning, Learned Counsel for the app.
Don't go to the details.
No, I'm not, no, my lord. No, my lord, I was not going to go into any details. I was just going to say exactly what he told us this morning. What he told us this morning was that there's an issue that he wants to raise with the court in chambers. He doesn't want to take us by surprise. So he was just mentioning exactly that there's an issue. That's all.
About the witness?
Yes.
These are
all rise.
Omo kwasa aba. Lawyer. Now where are they here?
Then I go so.
Yo. Tell me yet saying one application for inspection of documents we're refusing. Nanka yina ya chenyi midenka. Either they were caught in the back of the air to into a biana a message in Mensa and also our best starts in the case. But I want to lawyer chachu or sorry no kede or one potential witness another will be order when I joined the that's in Nibia order when I joined the waped war friend. It was a health in the crowd back and no cheap man other friends. The Chief Justice is and then them potential witness and one file a witness statement that they were not to do. One file a witness statement in our class since them the water work and some chambers into going to water there. Into when I joined the okay, them as I say I was sorry. No, I co chambers, no we can one briefly, no one's a number.
Intina chede oye chachu chikata no ono opede nche the next witness no oba na de where is the demand for that next witness?
I saying that some me are all patching now. Opede was what said the obasna free witness another witness.
Okay.
Maybe a damn witness in will be an unya nampum no hundred do on the cranty. Opede woman watch your courts and since you know one file a witness statement na ebi anasam ken woba pere woba kan nasam wo kukum it is a work on a judge court need you to me there woba ma hon kona na ebi afi no woba file one witness statement
the next witness statement
another witness statement and so on.
But by this time them the next witness introducing the next witness no by the time and only late another is admissible.
Oh, late do I mean honestly late do I but
because this witness witness statement Nankasa has been long in the proceedings and the court decided. In fact, they reprimanded the counsel for petitioner. I gave you time to file a witness statement. Why haven't you filed now? Then they apologized, and so by this time we'll finish. And the court even gave them a certain leeway. And that particular one, the court could have even struck out or made a decision on it now. Isn't it late now? I mean, and what difference would it make if they add or they don't go, or the court decides I won't take any?
Well, it will be up to the court, we decided over Mahokona, but me assure the Nina and Sina will be a World Cup court nature, the Mahon one file, maybe a witness statement late.
Additional witness. Because you see, initially they indicated they have 5 witnesses. They failed in filing the witness statement at the given time per the order by the court. And now the time given them, they were able to make it the second time. But they only brought 2 out of the 5. And now you want to go and add 1. How would it look like?
Yeah, usually there. Or they file a witness statement, and sign what we call case management.
Yes.
Until file ourselves with opponent, in the court and saying no copy. Until maybe I started trial. No.
That's right.
Until I'm wondering how our court no, but when I some but this is Supreme Court be to me see because I'm sure maybe our court na kakade. You be so. I say only buffer 5.
I will cry. Initially, they put the BMI 5. HNS 2 penna.
2 penna. Yeah. We trial now start. Afe na it's bepe another or the handbook because sisi and wafa. So omo kon mo file. Afe no wo be say. Time washum. And Sana was the witness who are betting a boxing, and there's a video conference, and Sana was cross-examine the witness now working some so because me are sure that court in Nigeria can neither will we in Kanda or about your
over correspondence witness and
abandoned the Supreme Court over back.
Wow. That's interesting. But I see an application for that particular one with a certain limping leg.
I will put my academy.
That's what me I say. I see something like that.
I was as a journalist.
A certain limping leg already.
Very interesting. Yeah, I mean, I should be Supreme Court number, but don't you me one there or back there? No, and I don't you one was back there yet. Of course, Supreme Court bit my can be in the interest of justice, and I know which one will decide the world.
You see, I'm asking all this because this thing that is happening has a certain time frame.
Yes,
that this thing is supposed to finish.
Yes,
and until the first one now. Then anything that is admissible, or even if it's not admissible, for the sake of justice, as you said, let's make room for it. But this one, we all have been through this thing before. We all have to make the system finer and better. There may be an wine within 42 days. In fact, that 42 days requires whether 42 sitting days or 42 working days or 42 just raw dates. Now, there is even contention on it. It's a difficult situation for the judges as well at this particular time. If they're able to, if they want to introduce a new witness who is going to file a new statement to be served on other parties to be studied, which could, if give me a fair idea. If the judges allow that they should go ahead and file the new witness, I'm sure it will take a day or 2.
Yes, I mean it's a work there. Court in Mahokwana, but of course, court in Bitman Mahokwana. One filing by close of day today. In the crowd, but my catch over there. Yabama Okwan, ordinary in Kayama Okwan. But Yama Okwan filing by Emery.
Okay.
Not 7 one.
Okay.
Now Ochina Yambra another Friday.
But because the parties that to be served also need time to also go through
and
it
prepare
now.
the questions. I would be someone as they can. And actually, when the Supreme Court. They have consistently shown they want to meet the time frame now. CI 99 is I'm one. There's always most decisions inside the back of their mind. Don't work there. Our friend and we are bound by time. We are bound by time. We are bound by.
Chachukra raises let's not sacrifice speed with justice or whatever it is.
Yes. So on one where there or back there. Time factor into what one
they might not take it.
They might not take it.
One of the strong reasons why they might not, they may cite the reason why they may not be able to take it.
Yes, especially when one more opportunity to file all your witness statements and you chose to file only 2, and then you didn't even indicate to them that along the line and you will file the extra one.
Yeah. But my main the judge's decision in general.
Yes.
I mean, the decision has been made. But what's your reaction to that decision by the?
So you go by precedent, which is in age and my friend precedent. So why you be there? If you're more clearly no. I think that it's a fair decision. I mean, it's a fair decision.
Okay. We're here Angel TV. We're also live on Angel FM 102.9, also on Radio 1 in Kumasi and other affiliate radio station and TV stations. Young Crossoko, Yenia Kofi Adomang when you are a court down on Yenia Ba Ama Bracon na Yentium Sena court down SCTA after when ya coffee. So somewhere on Yama Nakakra difficult down so my Yehunia Koso. Hello, Kofi. Kofi Koso, yet you.
Angel 102.9.
Okay, Inuya Kofi Adoma NT and Kam say network di hwemo kakra. Besa ye network no adwuma ye besa so akoso election petition ya akoso ewo Supreme Court. Court no ekọ ejina etoso mienu. Ejina ya etoso mienu. Na sa ejina etoso mienu say ba behwe say court so says your court now sorry no what are they going to decide on now?
Sister, we could decide whether there Obama,
the third
President Mahama, Obama Nkwano, or the third witness, Abba, I'll file a new witness team. So I filed that there was a commission there was a problem with the Wobbe Nipan because ne health into Wobbe taken in chambers and another 1 year. But
can you call this one a backdoor application or something?
But
the lawyers have certain ways of describing certain scenario because you have not filed it. But now, per his statement, he wants a third witness. Is it a backdoor or something?
Well, what strategy was it a case in? I don't want to say it or a backdoor, but maybe.
Question is
Is it a strategy that when you have a bad case, you sometimes have to re-engineer faculties of the court?
Oh,
I was in my young faculty film. Another one. Coffee, what's a maker? To us, Obama, Leonard colleague. Coffee, yes, Coffee.
That having. All right, so say, you ever found a court no, and yes, one more accord a year break and Casa Sabia. Say omokwako didi anase bibia tesa te say di akoso chachikata nensa opegya ye se omo wadansini a otoso miensa a ompese nka court no makwan na ode na dansi a owo ede eba uti atemuafo no ensem omo bisa ye a sa nipa yi otwere na no asem ne nsem opese ode ba no eba ya na ana say my lord o hwa nipa no ontia papa and nti the entire went me antro and some no and nchiremu e wo ho ni nyina no mempese ye beka no court dan mu ha na nke yakɔhye kokɔ mu kakra na ye ne atemuafo yi nyina ne lawyer fo ho nyina no a na nka nchiremu no atumi aba ɛna nam so ma ye wo mu a ejina mu de amama mpani na na dodan kwakufado
Kofi Ahoma no ye ko ho enti no
ye sa asem wei anase kwa ye twen se won betumi abopo no ho me atomo ya okay enti ye twen se won beba na de metumi se si ade me hu na manyoku mpanimfo ni bi aka wo ho abomu akogina eye dua bi ase wo ho me ho Peter Boama Otukono me ho Johnson Asiedu Nkatia any party executive ni bi wo mo ehye dua bi ase omotototo wo mo nsa se nipa kopoti anadanse eba ene hwan ene wo yare ewo NDC amanyoku ensem a wo mo kan ko wadanse a ama ontumi emma no ade asese esentwerefo na ye hu ebi susu se ebetumi aye rojo metal nunu ebi nso se na se rojo na ho nyesa wo yare so serious se nasem ese yetie abra yemfa camera entono so nti sabre ama ben me kakra na menhwe na ma wo inside ho bia na watumi apeke info kakra with regards to it say dia wo hwe no NDC amanyoku executive a wo mo ate wo mo ho na wo mu di nkomo ba kwa na mienu yenim asem kopotia wo mo adwen ho say nsem no ba bia keka kɔ no se ebetoa so enne se ntoa so enne no yentumi enkyerɛ fi se temuafo no ne lawyer no akɔhye dan mu a wo mu di asem ne fa bi ewe dan mu we ne nye lawyer no ajagefo no nko na akɔtena se a wo mu si agina se the first break na ba ya na wo mo de ruling eba no we na akɔyɛ se wo mo ne lawyer na mienu megidi sasa breach achu advancing the reasons na ampa nso pagya ne nsa ɛkyɛ de ntia wompene so ti megidi se na sabre ɛkɔso ɛwɔ dan mu mensa mu akɔ bi abra mo sorry ye no na ye hu se cameras na da so ɛwɔ inside ho lawyer no wo mu nyina na akɔka atemuafo no ho ɛwɔ dan mu ho anase te sɛn
Midasi CJ announcement say esan COVID-19 protocols nitin was the lawyer Justin Amanuvo no lawyer ni edem electoral commission sanso no fra kuto ampa nko a unse nanado lawyers ni 9 na emu mo say sakuto ampa nko anemra eno achi eno fra say chachuchi katan so enka ho kona omo kono enye se omo kwakoto asem ni die ni so o say the odi kind to jan chachu eyi court na sutire ewie ya say anopano one a lawyer for ankaye no esusu asem bi ho na wanhye da nka asem na nsi so ne o kanya na se omo adansini fofora o si o yusu brofo kasa se potential witness a opese odene ba na emo nse ne ho dodo ne kakra na ompese nsem chofo wa ha timamufo nsu tie nti na ompese obebo nsem ni nkro ni nyina ewodwem nti wo sese omo ko court dem ho ebeka se chambers ho na wakɔkyerɛ se ebia eyonipa so masi yare se na ebia ye no obetena adakema ebia ne health conditions ntina ebia ne ye makwan ma cameras emfa no life anase kwan bi opese ye nam so na so onipa ne nko an ye kana asem ma CJ kwese ani ye body kan bi sanse or the witness statement abana and or say ni nyina ka ho bi yare no ne onipa no ebia ne tebia mu ntina otutu say asat now no omfa nto say the odi kan me de maso atoto form kakra ebra court ni pagya omunu enti ye nsem twofo ye nya ebi no say Roger Metununu esan so hwe nra evidence that Dr. Michael Pese White e de bae na dodo na asem na omo kan say aden na papa na no was strong room or signing document ahoro ni nyina ono ma media dance say information na epic say ebetimi aye Roger Metununu e bia omo koba eni be hu nipa ko a ye ka ne ho asem yi
your name health
This is Angel 102.9
court them who are asem definitely obia ewo health conditions ba ko na mienu bi o shan kasakra already about chachuchikata at age 4 and onya asthmatic attack nti ono say or asthmatic and it's a health conditioner obia wani there but we can't tell health condition kopotia and enti we dear no young timi infa camera to almost na womo any and they are there to say yeah train na ya share how long that will go but quickly no yeah share really na a buy me who say chachuka say said the court more than mate and ampa so sorry and I say yadam say euranum my idea I say you
This is Angel.
You are Taubia, family. Jiboba, yes, or not, where German the amount. As I say, any be and a course so, say, send and not here.
Kofi me dan say Rebecca say court ye wo ye mra ene kwan a ye fa so e kan ye nsem wo court dem mpem bebre no enye Rebecca say Supreme Court kra ukọ High Court Circuit Court kra na say u de wasem ko na ye fa bi yankwa ankwa ma wo a wo sorry a uka che court ne say said the court no ensusuye mo pe na ote ase e na waje wase nti o ma ko yiye de ma am de o se Mira medase ese ekoma me enti meka se ne na chachu eye no ne kwan so anu enamo but ohwa na nani anje but ruling ni mu ankasa ne de na ase argument ahora eye easy lawyer Justin Amanuvo ene nanado lawyer akutampa oye ne de na obeka se ne na omohwehwe na court ne ye ma enti na migiri se I'm sorry ya ne ese so omo ye kire court ne se yera ye da se ko yie ma ye more kind of okay.
And you tell ruling now reasons ma womubo chachu asem no etugu ye ma say NDC nipa no a womo kotu agina no Peter Boa mo tuko no aka Chobwe DJ Boyajom wa shane political suitor wa gene no smash tum na wa shane red beret no oba ye senke ne Bra Johnson bedin komo na nchemu ade ma ye ne se court abono kokko se enam se oye dance ni e wo sa asem we mu se de edi kan ebo a lawyer fo no kokko se mo wo mon kasanti no enya de a obetumi ene ya kasa e wo eye sa asem mu but yen hwe ensem a court gina so pi is it to say or say okay mon kan o court wa se adansi a pink sheet na ade ya mo pese mo kokko obi de no mon kan da se mu ni bi eni ntine ma mon hwe. Was that the key reason? And I say other reasons some boy you know utie the whole ruling no nchiremu e ba ye no
me dan say eno a key reason ba ko a ohwe ye di kan kra e be analysis na ye ka e wa ha ese eno a key reason mo nyina court dem ha enka say enka ne mampeni John Dramani Mahama ye man ni pink sheet eno a one key reason na key reason ba ko am san gina so CI 127 no eno na ebra CJ edi ni ruling ni ban o kan say
This is Angel 102.9.
Yeah, wo kwan say appoint agent mienu enye national nkwa na kwatena enye regional nkwa constituency efi constituency bia collation center bia anase polling center bia ufi wa waba regional centers ni nyina.
This is Angel 102.9.
Mistakes no to court in anim ne to so biem no so no o se dance fo mienu na betina adaka ni mu ni nyina so aka si na ye omonwanwa se mo wade ne de ya ene mo mfa dance bia so meto court na anim che se ye pink sheet ni nie ye hu ne se mistakes was so enti na mo my original copy no na ye nti court na sama omo ka meka se me bone tofa na ye mienu omo chem se CI 127 no e ma ho kwan se agent enko efi constituency to regional to national mo ye ne sa pepepe e kire se pin sheet no mu woni nyina 275 constituencies mu woni nyina e na court dem a mo nsem na mo de betu dwane so bibie ni wa e kire se yamfa sa pin sheet amfa mam e no so na court ni gyina ya o ma bon mo nsem ni nyina ato agu
and easy or inside
isi wo ho commissioners mienu no e ka ho na ma men kan we say calculation bi a ene omankasa fam omomiensa Dr. Bosman Asari Jane Mensa na Orasa Motete eye wodam ho minim se ma men tena dakema e bia yi na sutire se obeye calculations panti yete woni nyana mi bisa men crop men afofo ni bi eto se na calculation o mafi ase ye na un se o calculate a no wa chiro figure na dey ato white paper bi so no wa calculate no dey ato white paper bi so ene san se bia yete no
wanya apom ye sure so wanya apom
we dey bia meje de kwakofi meje de se bia wanya apom ntu se o ma calculations ahoro a document na ye di bia brewom na o ma calculate and ba kwa me hu ya na me ame document no exhibit bia na ye general say dunketia e wona witness statement and no ye Eastern region na there was a bone of contention na ye chese figures no kekamboma enye me hu ne say o ma calculate sa figures ni nyina e de ato enti me gidi say court ne ba na say ne ebia mahama witness ayese o ye potential witness o metena dake na say ma me ne betena dake number start edu ba bi ne close na no de me gidi say na ebia calculator ebe sign e di ne juma bi mpa
we no na kese wo man kase do ma calculator ba because me kaisa theories bi ba ya say ugina daka mu na nipa obisa wonsam ma calculator se je fire ya no aye careful na calculator na yetumi program na samwe bi a oboba e be si na nsem ene de you need that proof we no easy ono ankasa de ne calculator ba na say ono so bi o use ni phone na de ne calculation
so far make say ne me hu ne na eye ni phone omomi ensan ni nyina obi akura ni phone na hu say omani abra omo calculate wo so me hu calculator te say ne de ma general bia ebra no betina da kan we de na omo ankasa omo phone omo de calculate ko ma men kan we
no how possible because menim say court dem ho ye makwan emma eye phones enwura inside o me kai say Johnson said in Katia question be ebisa no okay say unfortunately you have seized our phones and you know ya mana when you use the phone and find any calculation ya man calculator and no they I don't know say be different in here they more there
minim but ne me hu ya ne say Orasa Motete epie na orem nu na okra ni phone opie nti minim say okoje phone purposely for ebi adwumedie na ombedin owie ye me hu so osampie e na me hu say Dr. Bosman Asaren so SMPA as to say phone na omsande kogu eho anase den but omo ye omo calculation ni we me hu so omie no nyina esan sorry epie ya omo ba no minti mi nche se na ehye ne botom anase okoja edit to by but omo ye omo calculation ewie ne na me kaka hu say adie bi am say ye fi ase me hu no say ye yi camera ni fi o te se mpanifo asori a ye yi cameras na fi on okohwe nkomobo a ekoso ewo NDC ni MPP for Afema me kai say titu first day enka ne mampani John Dramani Mahama bae Freddie Blake kwatina ne nchen ni di nkomo sere ya iya ne yete soro bi ase na enkrofo eni omu ye de na ase we command nyonko club we command nyonko se camera ni fi wo muso a na oti court dem na hwe ayonkofa eni gie a omu di nkomo ne ade a na hu se no kure ni nyame anim eye feyie odo ne ntiase e wo mo ntem despite say omo ba bontia hu se kasentwe kakra bi ni ade e wo hon court inside there bawo fi meka say eya edu ba bia ya na anika edu ba even chachuchi kata hu se oni akoto ampa ya argument a omu wi a omu hia na we di ne nsabo ne we nsafa hu se bibia ekoso kama fa e wo ho.
All right, na cameras no a flash court demo ho esusu se enche atemuafo no betumi aba but womo asan eye ede efri ho enti ye hwese womo pie ba ye womo ne lawyer fo no pie ba ya no ye besan afa feed no ene de ekoso ho no ede ama safe no aka ye ho a de SCC an se court enya empon ye nemom lawyer chachuchi kata asusu se o wadanseni bia opesen ko de ne beka asemi eho na danseni no ompese ebedi na asem no e opete mu efise nipa na yare na enam saa yesu nti no wantimi antwere ne statement amfa ma na opesen ka one atemuafo no ebesi agina ti wo mu si agina na se wo mu gitum de a obetumi ama na kwan na se ampa ne isi lawyer beji atum na yenimu de enti eno na ama sabre yegina ha ye body akoso ho no ene de yehuhu ha ye bo ebi tofa ede akyerew enche ye na NDC mpanimfo ekosi ekotu agina ewo akwankwa ni ase dua bi wankwa na ho a ene ase ho na wo mo eyom Bible studies pa wo mo call ye ko gina ho to wo mo nsake kan semba ko mienu a na Peter ba mo to kono ene Johnson Asiedu Nkatia asan abewura eye court dem mu aha enti se ye wa atwene mu a ye hwe se ntutuye no be kose de wo mo ehwe na asem no etumi ato so wo hwe bre no a abodonko sima mienu na apa donko ho enti se kose de no ekoye ne de anake se bi o mo ba ya abehu ana wo mo apon but ankoba ne sanso de a ebia depending on ruling ebeba ewo dem ho no said ya che de na kese akoya anoyiye kakra na hu sa chachu nso o chere ne nsemu a onya abutra chire mu a mewa nti se oko objectia obesia ba no aba be chire de nti a oje o chere ne se ya ti we can understand de nti a bia ache but ebe gina nipa kono se na witness no ye de emu edu na ye Penia lawyer for who say, so same way by betumi ahaya. They also find a way to object. A lawyer for now no be a person as me de. Entino or her na the other day ban betumi say na semwa obaba atwegu. Enema edu baby e kwaya say. Na say e betumi abasa wasem we de pa. Nenso o file case no adanse be mo wasem na ye de no. Wan fa nka ho. Enti enam saa yeso nti bebu atia nti eno nkyese wasem nye de
eno nkyese wasem nye de ahụ se nti ne ma o kwan se ko na onyo dansini no nkotena se ni oni mfa asem ne hu nyina onka na twero migidi se oka na twero wie kura unya bre ne adaje e kan emu san kyere no se de be ya mistakes bi wo ma obehwe no correct sa mistakes ni nyina enti se ukotena se na bre dodo a ye de ama oni nyina wentimi a mi se witness ni nyina no wanke kan san nsem na moma fa metoko na hwe de na akotampa o ka se bebia ya kan sem ya kwa kodua se mre na oba be ka se afe na yema kwan na be file another witness statement and na say adansefo no odi foforo ba be ka ho na say yema kwan ma kofa fresh evidence e de ba be rem and na say yema kwan na kohwe sa nkrata na obisa na say yema kwan ma de fresh evidence ba be rem nti migidi say yema obere na say court ne ka cho say yewe na court na fie say o ye lawyer o relax ya ene obi ka say dua no wa ne be bu abo.
Eti say minimum say mwatumi enya the number of say 42 days so say how many days yi wo mo calculation wo mo ye ne say ni woni lawyer for ni bia di nkomo per days ni atwa bi akabi anasa mo calculate no sitting no dodo anasa weekends no mo kan de aka ho o ma clarify ho no
Kofi asat now almost say your starting case ohwe nanado lawyer for omo chem say the 42 days na eko Okoshe MPP NDC lawyer for Dominica Yene Chachuchi Kata any Tony later. Almost be edu baby omo analysis ni kozi say 90 days. Say you call by 42 days ni dia. Hwiebe anka yebeka say first week in March there. Na ye di bibia akona wie ye. Ohwe calculation na NDC lawyer for nso ye dia. Na yebeka say ne ekeka ko March ending. But Kofi Meka say ye start ye process ye better to say ye wie pre-trial. Ye beka se witness ya dance for mienu ema nka ne mampani John Dramani Mahama se de bia court ne be sete de a ene na hwe ya 42 days no pepepe ene ye di bewie esan se dance for mienu na ye beka se ye nim so ho betna dakam be check cross examination ne be che no within 2 days ene ye wie na hwe se de ye ka che ora akotampa o se ye ma odakoro fire cross examination ni wie me gidi se sana ebia isi maame no betna dakam na ye catch and say owura chachuchi kata ye ma 1 day ese fire cross examination we ye makmenu so betina dakem na ye catch chachu say ye ma 1 day na fa wi me gidi say memene da ne kwasi da kora nka ho a me gidi say 42 days pepepe no ye betimi e de awie
sisi lawyer for no na wo ewo ano ha ne nyina ne wo mo asem no wo ba behwe bi no ma hu se wo mo nyina ara hye inside ho menim se wo mo nya indication se enche asetena no ebetumi ato aso but ye ni etuemu ewo court dem ho enti se wo mo ba ya no straight away ye be cross on ye wura inside ho na ye de ho ensem no e de abrawo ye gu so e was Supreme Court ye hwe ensem but mama hwe a lawyer for no on say ye wo mo edikan lead counsels na chachuchi kata ampao wo mo lead teams no video bi abaketo bi a asa kotampao na o cross examine menim say Johnson Asiedu Nkatia na one of them a lawyer for na eboa no ba ko kan asem bi e ma ne ka se he jasa eno ude put it to him enye yi e ma asese no omo ewa chi no omu role omu play ya yenhunu ewo TV so na ya wa bonten ha no se de ehwe no no role ben omu play omu twetwere mo omu kan go mo som omu ye ne den
me da say role no dey make say bebre ne di kan ohun say empem bebre omo kasa na wafa enwoma we na wahwe enwoma no na ya twere wo ho ebia Supreme Court rules no order this omu bie na omu de paper ketu ebia na say pen ti bi no de ahye ho e de ama no eno ye role baako obi wo ha ne dwumadi a wodi ene say enkrata bia se ye hwe no ka ohweso no ode kasa no obiebie sankrata ne de to e de man enti ohun se o kasa awie na no besi no so fa sankrata we de man no wa che ne se aha e na wadi ntu ete so kasa obi nso wo ho a ne de ne se enkrata no ya boaboa no awie e de ni nyina bedru court demon ete so ohun ne se ofiwe a e no beko we ofiwe a no beko we e na te se Frank Davis na kagu na sum e na ma akotampa etiano na mejidi se na o ka sembi ena no hu ni se asem na o kan ebia anka question of obisa no in this direction anka beboa mejidi pa se eno na ebia Frank Davis pesa oye ena akoto ka chense papa we dem se me bisa na o de ben le me down nti a lawyer for no omujumedi a omo ewo na chi ni hwe ni se ne o kan no ebia obisa question bi obi nso de ne se ebra ye cross examination no o questions ni bi to nti okase wi a na waka chense nka ubisa we nso a eye nti ebinom church questions no na ebi nso tro potential make us questions ana say nsusuye bi say okay yemfa order we emra we wo de kan ho ye esan say court dem on emra na de as time goes on na say ohwehwe bi e de kan nti obi a woni rule ba dodo na ehwe say enkrata na ode ye adwuman eye pepepe onka say order 25 ebra na ye bia order 27 ene de ama no
abra court na ekoso no temuafo no ka asem bi ma chachuchi kata sorry anopa no mu ho na wutie asem no na akoye se enchiremu a temuafo no de eba esusu se de nti omo court no enie na chachuchi se my lord enye saa se total figures na ne ye hwe nemum se total figures no ho ba asem a ebe kire se ebe affect we could it be say explanation now wo mo manate mafo no adwemu no wo mo ne se we ne ye hwe na a lawyer for ne wo mo so de asem na ba court no so hunu ne se we ne ye hwe because it looks as if say that issue no eba up and down or even adanse for ni be correct make us my lord enye we. Are you getting that same feel we're inside of?
Yeah, government one is one say and you can Supreme Court now set 5 key points omujina so edo matemu naba na otemuafobia won ho kwan say wo de wasem ba court na wo kan wasem ni nyina awie no ono ne nsusuye mu ne nimdie mu onte ne wo kan ase a obisa question. There were several cases utimi ebeka say bia murder case bi kra na doctor the reporter ba say onipa so mesi we ni ekun na yetimi kofa doctor ba enyo no ye pathologist no but ye de ne ba say brofo kasa we ya doctor we report no de ba ye no ye ntiase bra na be chirechi ne de ne so o chirechi nti ne sa enotemuafo bia wo ho kwan say obisa say wasam na de ba ye no ne mpompon so ankasa ne nyina so ankasa no eno ene de yen nti miji setemuafo na obi beka say for clarity ono pese ne omo twro ne e ka no omo twro omo so make omo note say dem sem twofo yete wo ye make ye note no nti wo ka asem ni nyina na agbo ne tofa wi a opeso ote ne ho ase say so ne odwen no eno ano no ne otwro ye no onya ne correct obehwa anope gatrutokonu ebisa chachu ebra okasa ni mu say opeso hu ni say point no make na no capture ye na chachu repeat edman enti meka se eya na wo pese ne wo kan ni nyina ene ne ono so tworo de to ho no eye no ano no ana enti se ebia na ne otworo ye no a ono fo se eye correct no na ebia wo wadwemu no enye no capture ya obisa no wa standing chechemu na ma no na fe wate ne ho ase enti meka se eye ne kwanso ano no but edu ba bia ya na mi ho no na ya mi shedan mi kwanso ya na menti ase se se empem bebre omu bisa those questions na eye na mi hu ni se a lawyer for ni big team fa ne se de ye kan na mo nti ase ana but nieminim kakra bi no me gidi say atemuafo no wo ho kwan saa no ana nchiremu papa a wo mo pese omunya si ase wasem san say den a omo ho na temu ni be fiaba.
It also was Supreme Court of Ghana petitioners Mr. John Dramani Mahama and na lawyer for omade oman Ghana batwo nsunsan so awagina court na yeguso a yedi ho enkomo ubun konta no abaye sima baye di asani na court call break kakra enye break se omo kodidi ana se break se omo fa asem foforo bi nemom ya asem a chachichi kata erezi yese o danseni bi a onyaye anke ye makwan na yentie na no asem nemom na asem no kra no ma yentie wo pete mu yemfa nkɔhye dan mu na yentie fi se nipa no ho emfa no eno na atemuafo no ene aloyafo no akɔhye dan mu sese ya wo mo etu ho agina atrust mabaye aduasa sese yenhunu de epie mu abase wo mbagi atum anase wo mo enye eno emfa ntum no eno ene asama sese yeguso a yehwe se de ekɔ animu ha yebo ne nyina ne se wo mo a wo mo ho asemi mu ebi no wo mo anyina enche na wo mo wo abonten ha wo mo asan ekɔ inside ho meaning se enche asem no ebetumi asan atoa so enti wo mo hwa asia no ye besan akɔhɔ na ye de ho nsem no etumi ede abra no achi wo mo wi a press conference said ya wo mo ye ne brebia no eno nso wo mo nsem mo de betu dwa no ye betumi ene yetiefo achebi na mo etumi anya bi ahwɛ na mo atie bi ama say inside ho no wo mo ete ho no wo mo nya aduane di
Kofi inso cry ma ye no bi wo inside Isio bottle cry unze Supreme Court make us a sachet cry unti me fanko but bottle day 1 na efi ase ne de ye ma ye kwan e ma na ultimate the bottle water ko efi day 2 no minim directives a e bae ye sisi to obi amfa nsuo ma unze wie ya wokasa wo se omo ebegina abontini nyina lawyer fo ni nyina ko ebra ye wie analysis ni wie ye na mu amefru restaurant na court clerk no ma announcement or de ba wo se atemuafo ni se ye ka court rise na obi asori a kasa bebre wo dem atemuafo nsa omompe ne etoso mienu omo kire se ye ba late ye ba court dem go late ebra o ma set no na afi ne nkrofo nante ba eno so distract court no ti megidi se enti na sa order ewie ye ba ye no enti na a lawyer for no be nante ha kakra no megidi se omu nyina asan akọ but edem ho de Kofi nsuo kra onya bi nom na ato aduane unti mi nwe gam kra no meka se ene election petition ti na ohun se nkrofo ti mi re o ma no ho but on normal Supreme Court days ni de you dare not say oba we gam kra Supreme Court dem.
Very soon, you will send by AJ Mama our studio na ebia LPMs ne commercial kakrabi na ye Africa court no assign eba ya no ye be sign asomu ha na ye de ensem a ekoso ha no yetumi e de Abraham quickly on the whole ene safe no bi akan ho a boni nyina atofa se be na nipa no enyira wo
ene ni nyina me kasa me bone tofa enura application a eye motion on notice a na oracha chichikata no ye lawyer ni edeman kane mampani John Dramani Mahama eye request and was record this tanka court no enkanche electoral commission say from 9 from 10 from 11 from 12 from 13 any updater omususu say ebra electoral commission ebe declare results in wie your case mistakes biaba into the number for be 2 dwa no sankrata no original copies no ye ma omonhwe na omfanto to wo de ho na no na court no ekwa asetena ema akwan ma omutie afane ofan obia de a lawyer for be kasae omukasa wie court ne sorry ye be simaduasa ko aduasa num omatemu anase ruling na omode ba nyina ene se NDC amanyoku enka ne mampani John Dramani Mahama dano no ona bibia di nkyere se enkrata no oni first witness Johnson say dunketi o dance ni odikan second witness dance ni otoso mienu Dr. Mike Pese White omo betina adakam no omo da na di pefese sa enkrata no omo wo ena omo tam kyere mu se CI 127 no so da na di pefese SSA ye beto aba amanyoku bia o ma nipa mienu se agent eko constituency bia region bia ene national ye strong room ho adansefo mienu no e kire se omo di se adwuma we eno achi petition a ono eyen kane mampani John Dramani Mahama petition on the back court no ono so kire say odi sa adwuma we enti court ne kire mu say bibie ni wa edi adanse sesa enkrata no omuni enti omugye omo nsem na omo ka no etuma enye with the issue of audacity and I say authenticity nso no court ne kire mu say ye ma pink sheet no yetimi gitum wo court them as evidence enti so wo pink sheet na it is original copies no enti no court no abo sa ensem na no de beto won na nka ye nimsa nka ye wie oba pani ma electoral commission na betina dakam no no so ya start cross examination emu na lawyer chachuchi kata abo court na mane se owo dance ni bia o yusu brofo kasa se oye potential witness nemo ne hododo ne kakra yare bi wan kire se yare A ana yare B nemo mo ka che court ne se one a lawyer for EC ene na nado a lawyer for esusu ho anopa nti opese ode to court danim court na ma kwan ebisa EC lawyer just na maneuver say owonim bi fa we hu ono so kire ni onim akotampa so kire ni onim nti court no osle court nse beye ya anka ompese omko pie mu ho na omni atemuafo ne kosusu hu eno na atemuafo ne te ase efre lawyer chachuchikata akotampa ena Justin Amanuvo say omomra pie mu ho enti pie mu ho na omo no omo kwa kosusu sansem we hu omo pie ba ne omo ba beto court nanim ama obi ati bi no ene ebehu beka say the way forward enti ene mebo ni nyina to fa dia meka say ne tension bi ansha dan kosoro ye hu argument bi enfi atemuafo no ene lawyer fo ne nchen ene de fi anopa meka say bibia akoso kama security nso said de efi de one na start here bibia ekoso kama enti ye hwe say ombe fi pie mu ho aba na ene ne say ye bekọ yanim anase ye bewie ne ye san tu asem na hye da foforo no ni nyina ene maboni to fa de mate.
Alright, that was our 40. You better cross over near the studio. You better sign up back court to us see bra. Setnano assign ashas and I say or more assign atwas or every take captain. So to come in say nipa no so say COVID-19 when you antina ebia up in camera. Or more in camera but you hear me.
COVID so when you COVID so when you COVID so when you COVID-19 they send they say isolating the crowd completely. Tiano den kebia can we say you unim say you see handle camera near work with Jan and Chen with them.
Nanka
unko interview channel
but be an dance here ebia nanka bayana through Zoom.
Zoom. We're live. We're live. Face 101.
Studio Hona. About. All right.
Thank you so much. Kofi Adama Wanene ama Brakon. And Ote Wamonka from the Supreme Court of Ghana. Coronayo questions be a necessary lawyer. Now, but lawyer say, one more banner mujitum say this unknown witness. So mujitum say,
the possibility and then what the implication.
What will happen to the case?
Yes. So bendams out there, case in what you said. Now, woman, when madam witness and off file a witness statement. Now, what serve easy lawyer, nye na do no lawyers. Now once win your time, no worship, no prepare. Now one my data, them witnessing. I did over bet in a box in the moon, and now there was there no home for the paper. So we called Nifie. Now we set up cameras now video conferencing. Now we cross examine on also. So woman calls that damn now. I'm sure we see.
Lawyer, let me borrow Chachu's word. Irrelevant. He used it this morning. Our court. Dr. Pesa White, ne cross-examination. What the petitioners will seek to solicit from him to the Obebuon case. Really, if you just oppose that to Justice Appel's question after the cross-examination, do you think that really to achieve what really they wanted to achieve with him as a witness?
Question is, NDC for and lawyers and petition lawyers in the one what they were seeking to achieve through one witnessing. Obeying them to me, one obey them judgment call. Maybe in their mind and they are happy and they succeeded Ebusan one succeed because on your service I'm a witness.
All
Right.
Judges are entering the chamber.
Yeah, corner.
Yeah, entering the court.
I've been with you, but we on Antino.
Yeah, Chachuchi Kata down for that.
There be Mammy, you are taking them, Hano.
I know Chachuchi Kata down for that.
Yeah, she's got a very beautiful way of.
Chachuchi Kata down for Paro.
Street gallop is.
As a friend, a lawyer, as a friend, get to JS.
Her ladyship get to
Tokon.
Oh, Madam, I'll come visit you after the case.
The petition is hereby adjourned to Friday, 10 o'clock a.m. Friday, the 5th of February, 10 o'clock a.m. Thank you very much.
Be seated. All rise.
Okay. So, guys, I try and manage. Me and my sibling, I say, I try and court. But lawyer, not to say, what does it mean? He said they have not really decided. Say they have to grant the third petitioner, third witness statement, and be
but I'm the Antony now.
The Antony now, yeah.
Baby, latter part, but the way I was actually Friday. I can say be our grant one requesting,
and therefore they have to file the witness statement
and then serve
the other parties for them to study. So Friday they can come and then argue it out whether indeed near day.
But if the person is not well, how do you bring the person there?
No, they man. Lawyer can say they can do something. So we have screens and so we can do Zoom or something. Then,
but if I may ask, lawyer, about tomorrow bande, what by a cross examination, no.
Via Zoom.
It be a TV. It won't come on because it depend on the condition of the person. On pede.
Oh yes.
Gani nabo hunda o yere dami ya na bibi.
Oh yes. Broadcasting exceptional circumstances.
Yes.
And they can decide that we're in camera.
Because it seems that how they was sorry, I can't remember who said they really didn't tell us
anything.
Their firm decision based upon which the adjournment has been made.
They just said we are sitting on Friday 10 o'clock.
Yeah.
That's it.
Yeah.
You know, so but whatever it is, or probably they will want to do the in camera.
We are sure them if whatever press conference.
Details.
The details. The lawyers will have more details for us by way of the press conference, which is next.
Okay. But when you be lawyer question be, and no time we sitting no, as they do all the time. I hear train some baby you know.
Yeah.
A lawyer for the petition. At a point when he was being asked questions, said, "Me, I wasn't in the strong room."
Yeah.
Nipa me in the strong room. Back where witness.
Yeah.
Indeed, when the you said a maneuver, right? When EC first respondent, the lawyer Kasano, or can you see Supi say, "Don't get just say Oba na mebisa." And when the media people asked that question after the press conference, they said they were very happy with Yera Pesa White. By the fact of filing the because it doesn't have to take two people to be told say kokoya de mami answer nipa na ayeshmako
yeah
nipa ne de answer nipa no no koye na se osumesi say yenkoye we imra say waka kire no so omudi so moreover they needed two people to be there to fill in the gaps ebia Yera Roger Metal no kodu no ka kire o mampanyin dada say ya no we dey bi atum there's a person white on shadow by within the conversation na person white oh I dey crazy wa ha wan fan ka ho any idea and then a few things that asking whether it was signed or
in addition to Pesa White there no say after that no judges need be ebisa questions especially has to do with who ask you to go out and who do you take instructions from. Do you have to take instructions from somebody? I'm saying the court really, if they have to admit a third witness, they really want to know whether indeed, in fact, because when they ask him, when they ask him about PFI a strong room on, or say he, my lord, I would not lie about what I don't know. Indeed, is the EC madam. Later he admitted, say. Any no no Pesa White process on no Nedikan on the Pesa White on the mammy no easy mammy no any komo 1-on-1 when who ankasakra on no conversation be a moment any besides say under what form and as command no bar say free honor anyway, no so true Roger Metenu. No, exactly. And who says close to I'm sure said the judges want to establish that particular thing. Say indeed was a command who was it
a command given to Roger Metenu? Indeed, if it was, who gave that command?
Yes.
Why did he also take that command?
And for me, for the judges to be asking those questions, they are highly interested in the fact that indeed he's Mama
and again, Justice Appel was a bit concerned about why you would want to leave the strong room
when you have
the
a
National
job
Coalition
to do,
Center.
Yes.
When you have a clear
mandate
says you are not supposed to take instruction from anybody. You are not supposed to leave the room.
Yes.
Make sure the process had come to a complete.
Yes. And for me, I did me there back on to say indeed the judges will admit the introduction of a third witness, which we are thinking it must be Roger Metenu to really confirm. Because a ban indeed.
Let me add this to your way because another thing came up about the letters now. Or Muka said the complaints they made. In the Nuran Komodiemo, it was asked, say, who did who did you that particular complaint or the man?
Yeah.
Complain bang.
Let an control.
Emma, yes, listen, let her be na aka ho asemi anyhow. And it's also important to establish the complaint at that time now. Or say a man Roger Metenu no cry yes, error man sign form no. Yeah, because then after signing he realized he's made an error.
Yeah.
No
he realized there was an error. He didn't make an error, but there was error on it. How he signed.
Have signed, yes. And it came out during Pesa White's cross-examination. But we need to know.
But Chairman, strong room. One sign we are so because a hero.
You say me no a strong room. We know what goes on there.
And by this time around, I say because minister strong room. Media people all the time.
Yes.
And reps and so all the time. Hardly do you find them moving in and out of the strong room. If you find a media person moving out or by an interview, you are circle back. And usually the reason why Judge Bakubisa asks a very important question. Why do you think they sent two? In fact, it was it was supposed to be four.
So spokespersons for the legal team of the petition are now about to address the press.
Maybe they will give us some more info that
Professor Jenana Opoko Ajimaya Baso.
Oh no, say to all right with the.
Good afternoon. Today there was one main purpose for which we were in court, and it was to deal with an application we filed asking the first respondent to produce for inspection certain documents. Now, this was founded on a request we made to the first respondent on 19th January 2020 that the first 2021, that the first respondent should produce for our inspection the constituency and regional collation sheets, the regional and constituency summary sheets, as well as Form 13. We also wanted to find out from them the basis for the different corrections that they had made. So we filed an application, and our council made it very clear that the reason for which we are asking for all these sheets is the fact that, yes, we have, for example, the constituency and regional sheets. However, we need to know the basis for the different figures that the EC keeps coming up with. You recollect that there's a figure of the 9th declaration, which was quoted as the valid votes. There's the alleged correction that was made on the 10th. There's also the figure of 13,121 plus, which they quoted in their paragraph 24 of their answer, which was a sort of acknowledgement of what we were saying in our petition. So they've come up with different figures. We don't know the basis for which they have come up with those figures. And therefore, we needed to see the originals of those documents to be able to make our own assessment before we cross-examine the first respondent's witness. Unfortunately, the Supreme Court did not agree with our request. It refused our application on the grounds that these are documents that are in our custody. But while the Supreme Court has ruled, there's not much we can do, but we disagree with the fact that all these documents are said to be in our custody, and therefore we are not entitled to it. You heard the two witnesses that have testified so far. Both of them, for example, have said the Form 13. They have never seen or signed the Form 13. And that is at least one document that we don't have in our custody, the most important document of all. We've never seen it. Again, we've made it clear that we were not part of whatever discussions happened at the EC when the different corrections were made. And therefore, we need to see the basis for those corrections. Well, we've been denied that opportunity by the court. But that's not the end. We'll still continue with our case. Questions?
Counsel, at the close of proceedings yesterday, Mr. Chikata had indicated that depending on whether this request was granted or not, it may determine the possibility of calling another witness. We saw at the close of proceedings that another request was made about a potential witness. We know we are not supposed to know the specifics of that particular decision, but we just wanted to find out, is it a case that you are going to call another witness, or has that request been granted and you don't have to file a witness statement for another witness to come?
As you saw, I did not enter the room with the counsel and the judges. We are not privy to that discussion, and it's not for public consumption. That's why it was held in camera. You notice that when His Lordship, the Chief Justice, came and adjourned the case, he did not give any details. I do not have the details either.
All right. We know that he who alleges also bears the burden of proof. You have come to court without certain facts that prior to filing the case in court, there were some communications put out there to suggest that you did have all these facts. Indeed, today we get the impression that this application was an afterthought. You were not prepared for it. You had 21 days to have been able to put all these facts together. Why didn't you do that earlier on? Was it an afterthought?
You're entirely wrong. Maybe you misunderstand our case. We have stated clearly what our case is, and it is based on the declaration of the EC. Based on the declaration of the EC, that no candidate got more than 50%. It's based on the fact that there have been so many corrections to that figure, which nobody knows the basis of. And that is why we say that the declaration is null and void. We have come fully prepared for this case. And in any case, the EC is supposed to be an impartial part of this whole election process. What do they have to hide? What prejudice will be occasioned to them if they produce the documents for us to see? None whatsoever. If you conducted your activities as EC chair, fairly, transparently, impartially, why will you not produce the documents for us to see?
I want to also ask about the impact of the application that was denied your side on the case going forward. Are we expecting to see you call another witness, or would say that based on what we have seen so far, the two witnesses you have already called are the witnesses you have to make your case with?
I think you've just asked the same question another guys. You all see what will happen on Friday.
Yeah, I want to find out how strong your case is now, looking at the number of applications dismissed by the court.
We still think we have a very strong case. We are very, very certain about the case we have before the court. Irrespective of the fact that our applications have been refused, we came to court prepared. We are ready to continue with the case, and we will go through with the case till the very end.
The case has been adjourned to Friday. On Friday, are we expected to see your side cross-examining Madam Jean Mensah?
The case has been adjourned to Friday. The Chief Justice did not tell us what is happening on Friday. We'll all see what will happen in court on Friday. Thank you. Chief.
You are for yɛbɛda mo ase sɛ yɛbɛbɔ ɛnɛ deɛ si ɛwɔ court tɔfa ɛwɔ twi kasa mu a ne nyinaa ne sɛ ɛnɛ yɛbaayɛ yɛ lawyer ɛde ebisadeɛ ɛto Supreme Court no anim sɛ ɔnhyɛ the first respondent ɛyɛ the Electoral Commission of Ghana na nkrataa ɔmo gyina so ɛde ɛbobɔ aba it declares say Omampenye Kufuado now winning the 2020 presidential elections no Omomfamra court na afafa ni nyina atimi ahwehwem ahwese enkrata ni nyina dimu a bibia ededa nakwam enti eno ho arguments enenne ye lawyer Chachuchi Kata ya muti bi no na asem wo kan ye ne tofa bo mu nyina ne se sa documents aye ka ho asemi se court no anhye Electoral Commission for amoma ma court ama ya anhwehwe mu a enya de a atentene ni betumi aye adwuma na yatumi ehu emma dodo a epiem ewo 2020 presidential elections ni mu na senti okasa ne se yakoto abato baako de bia da yete results for on 7th December 9th December Jean Mensah or returning officer o declare results no the figures be two dwa what say oboso or the total valid votes or the two dwa in that declaration no 13,434,574 kwansima ade a chen ya na mami asanso asesa na no the figures for fraba the womb 13,433,573 after the total valid votes in Ukraine, another figure 13,119,460. You be peer court or so. No, I answer the figure for Fraba. So, figure original so they declare Banama and Penya Kufuadono. They say they are 13,121,111. Let's just say, according to lawyer Chachuchi Katano, figures no adoso. Ye name the documents in Krata is the agent so the figures we in our eba. It is a attention in Yaba court, no cranting Yaba court, near Pese Peri your year, Jumadia, and you need the Munos, as a court on a beshe easy. Now, modest and crata and abani in Ayetimi, Ashiship. Nasa request is to say you, and Yano Cresse, a Yenea no make his request, not to say, Yenuanum Ekaye. Or yes, our request no true idea your friend mutual discoveries. As far back as 19th January Senka we de e ma court krampo mam ya ye ho no mpanyifo so utimu fita tia mo anku enti se wonye boni bia de ma ye hwe wo documents a wugina so de sa figures ahodo nyina bai but the nam say EC4 anti asienti enene wode service ade ebeto court no enim court no de na temu bai de mo kan ne se omo ne nya adwen nti enya de omo be hye EC ama omo de sankrata no aba court ama yahwe because sa documents a ye pese EC4 de ba no ye woni nyina emra ne se at every level of the election process and I was say ye did be my agents na eho ena nidie mu ye ne court no enya adwen esan se wo hwe dance a eda court nanim na bibia kire pefe se documents no bebre wo ha NDC for ye ni bi for example document a ye friend form 13 enra yewura Dr. Pesa White dance mu eho ba asem wo be hwe a judge ba ko e de sa form ne kire no e sa form no ena Mensa na electoral commission for say omo wi abato no ho adwuma nyina wie no omo record ma obi anya ye wo so ma agency nsan ye na wo Dr. Pesa White dance mu te say wo kire mu say sambre ni mpo ano mo ye sa de na omo as agency no mu ni ho because na Mensa dada wo mo ama omo afiri wo say omo ne the flag bearer of NDC kwa ko dinkita ho bi it is out from 13 no omo ndi kosua say enhu bi yamfa ama omo krampo na campus o maka say yen sign na ye reason ni enti omu ni bi and for that matter NDC ni bi enti hot ye ni die mu ye ne court ne nya adwen say documents are ye bisa ye ni nyina ye wo bi because clearly no ye need from 13 whether duplicate or original ebiem it can be correct to say oh pink sheet polling station mu obi constituency summary sheet mu obi regional coalition sheet mu obi yes but ye nyina ye wo bi ye de ye declaration we on the 9th no eno achi Mensa ne nkwa ne EC4 akwa kukuom asesa no ensesa omu ye nyina no so no ye gidi se ejina nkrata bi so omo sesa ne wie no omo sanso akwasesa ne biem omo sanso akwasesa ne biem enti enkrata omu gina so de sa different figures na ba ne ye ni bi enti se wo kasa ye wo documents ni nyina ade enti ne ye sanso bi sa omo a na ne diemu ye ne wonya adwen because the foundation documents for the different figures they have churned out are not in our possession. It is a Nissan krata na a sidden na we be who say we na krata papa easy for you see and we nya papa na the trato obekaya eastern region collation sheet e ho abasem collation sheet na koye mienu ni nyina easy for the omosa ahase ba easy for a kire say ba ko ye papa ba ko nya papa say EC4 anfasa our originals na omodia ye omo declaration and all the corrections na ma esi then na NDC ye which of these two documents the EC used for declaration ye challenge in for it is not the case say NDC for ye nia dance ye bia na aba court na ye ba be hweda bi ba ye nyina ya ba court ye no kure ne atentre ne the person ye adwuma na electoral commission ni moto ye transparency fairness and integrity now no na say why abato bibia da wo fan o mampenye kufu ado awene na fe fan krata ugina so di hu so mampenye kufu ado awene no bra ne nyina ye hwe a o se me ma wonfa wani kosua mpo nya dan enhwe ti we asem se ba ye beja ya magana fo na mo ankasa mabua ba ye de ye wogidie mapase no kre ohoi eye ba kope aso nyame kokruko itato we no kre wa asem we bia mu no ebepie whether or not this application has been granted or refused enti efie da court the share say am ra ye beba so ye hwe ni mu say sanso ne mu be hia bi meda mu nyina mase say mo bye thank you
akade nyina unu ma dia pa let's pass
So, colleagues, shall we go? Shall we go? All right, so good afternoon, and thank you for giving us some time to share with you a few of our thoughts after proceedings were adjourned today. Right from the onset, let me give you a little narration of the background so far. We have been in court because a petitioner, Mr. John Dramani Mahama, has invoked the jurisdiction of the Supreme Court that, among other things, upon a proper reckoning of the December 7, 2020 presidential election results, no candidate achieved above 50%. And therefore, the declaration as made by the chair of the Electoral Commission is in breach of Article 63, Clause 3. And from the onset, he indicated in his petition that he will be calling 5 witnesses who will be adducing evidence before this court to prove that indeed nobody got 50% plus 1. On the first day for his first witness, Mr. Johnson Asiedun Ketia, you all observed how, upon cross-examination, upon various scenarios, he kept coming to the same answer: 47% for the petitioner, 51% plus for the second respondent. We were informed that he intended to put a second witness in the box who adduced further evidence that nobody crossed the 50% mark. Dr. Kwesa White was put in the box yesterday. The crux of his evidence was that he and Mr. Rojo Metonunu were deceived by the EC chair with an instruction to leave the EC premises during the collation. And upon further cross-examination, he admitted that the EC chair could not actually instruct them so to do. We have been waiting for the evidence or further witnesses who will provide evidence that nobody crossed the 50% mark. This is the gravamen of their case. Today, we were seized, or the court was seized with an application that was filed yesterday. And I heard our colleagues who just left say that this has been there for a while. It's not true. Check the date on the application. This application was filed yesterday. This application was filed yesterday. In fact, it was filed. It was served on us yesterday, but it was filed the day before. So this claim that this application had been put in way ahead of time is not true. That's why you heard our counsel talk about 34 days after the initial application. But be that as it may, this application is aimed at giving the petitioner an opportunity to go and inspect some documents. Inspection of documents generally is allowed in litigation. But it is not a matter that you have as of right. It is at the discretion of the court. And you have to convince the court or establish something before the court for the court to grant it. You have to prove that there is some necessity for you to be given leave to inspect those documents, because among other things, it will be necessary for the fair disposal of the matter. Without it, there will not be a fair disposal of the matter. And that it may also be necessary to reduce the cost of litigation. You heard Mr. Chachuchikata on his feet for about an hour trying to establish the necessity for which they should be granted leave to inspect these documents. And you heard counsels on the side of the first and second respondents argue that no necessity has been demonstrated because all of those documents are already in the custody of the petitioner. And the petitioner has not demonstrated before the court that there is anything wrong with the copies that he has, and therefore asking to inspect the originals. Because you have the documents already. Indeed, some of those documents were attached by the petitioner himself to his petition, some of the witnesses as well to their witness statements. And so the principle, the legal principle of necessity for fair disposal of the matter has not been demonstrated. And there has been no argument even made about a reduction in the cost of litigation. We also noticed, principally, that as the case moves on, and particularly with this application, the petitioner is now seeking to invite the court to breach a time-tested rule in litigation that he who alleges must prove. You come to court with your own case and your burden of proof is on you. It is when you have satisfied what we call a case, you have made a case in law, that the burden of proof now shifts onto the respondents or the defendants to respond. Indeed, if by the time you are done, and for those of you who are court correspondents, you will know, if by the time you are done submitting what you think is a case, the legal threshold of making a case under the law has not been made, the respondents or the defendants have the opportunity to move a motion for no case because you have not made a case. So it is when you have moved a case and satisfied the legal threshold that the burden of proof shifts. We are observing that this is an attempt to shift the burden through the back door. Now, the court, as you observed, rose to consider the various arguments and came with a ruling. Before then, plaintiff had made an argument that if you have nothing to hide, why don't you produce the documents? Those documents are even on the internet. They have been published already. They are within the custody of the petitioner. So don't be swayed by this propaganda line that if you have nothing to hide, why are you not producing the documents? The documents have been made available. They are already in the custody of the petitioner. They are in the custody of all other political parties or candidates who took part in this election. They are in the custody of the second respondent, and they have not demonstrated any necessity for it. In the end, the court ruled, and I just want to quote what the court said through the respected Chief Justice. Said the applicant has not demonstrated the necessity that must be met. In that, indeed, on record, they have admitted that they have the documents. No proper case has been made for this application, which we have spent a number of hours on today. And if you look at section, I think 166 of the Evidence Act, they have not raised issues of authenticity even. And therefore, it is not the 1 hour, submissions and English that would invoke the court to exercise its discretion in this matter. You must ground it in law and prove same. We are of the view that the pendulum swings back to the petitioner, who had advertised that he has 5 witnesses who will give evidence to show that nobody got 50%. We've heard the first 2. The jury is out on that one. If there are 3 other witnesses, now will be the good time for them to either submit those witnesses to adduce this evidence that shows they are supporters that they told they had won and then they came to change the story, but that will show them that indeed nobody won. Or if they are not able to put further witnesses before the court, then they would have to bring down their case, and then the respondents will also have to now move to their next line of action. We think it's generally been a good day in court for justice, and we look forward to the directions of the court on Friday.
So, Mr. Minister Designate, Mr. Kujo Ponkroma, 2 questions. The first one is that we've noticed that in court, most of the time, the petitioner's side is doing very long arguments, whereas the respondents, both you and the EC side, do very little arguments. What's accounting for this? And again, every time we've come to court when there's an adjournment, the Chief Justice will indicate what will happen next in the next sitting. This adjournment, there is no such indication. Can you give us some indication as to what we should expect at the next sitting?
I mean, obviously, you saw the bench invite lead counsels into chambers and have a set of conversations with them. We were not in chambers. We were not privy to it. It was something that obviously they did not want to advertise in open court. I am sure that that has an influence on the adjournment and the directions for Friday, but we are not in a position to say because we were not in there. We'll look forward to whatever the Honorable Court will put out on Friday. But to your first question, yes, as a matter of fact, you notice that counsel for the petitioner sometimes has about an hour. In fact, today you noticed from about 9:30 something to about 10:30 thereabout on his feet making arguments. And counsels for first respondent and second respondent are very crisp in their responses. It is because this is a court of law, not a court of public opinion. When you make an application before the court, you must satisfy what the law requires and back it with authorities that are relevant or the legal invocations that are relevant. For example, if you recall the application for leave for supplementary, counsel for the petitioner was on his feet for several minutes, but if you listen to the ruling of the court, it says that even the authority that you cited, Elista Maklu, has nothing to do with supplementary applications of this nature. And the expectation that you will give us good law to back your application did not happen. So we are not invoked. Counsels on our side, you would notice, are limiting themselves to the law and the legal requirements, are not necessarily arguing with the bench, and are speaking to matters of law. So what does the law say? That is what we are interested in arguing. So if under CI 127, under Rule 44, there's a clear provision that forms are set out and must be made available to all parties. All we need to do is to invoke that. We don't need a lot of grammar to make our case. And that's why you would have noticed that we are not spending too much time speaking English, but we're speaking law.
Being a journalist yourself, you understand how we get when we don't get the information we seek. So, follow up to his one of his questions. Do you have, and can you help us with any indication as to what would happen on Friday when the court reconvenes?
I cannot, because as I've mentioned, we were not in chambers with the judges. We are expecting, and if you look at the natural flow of this case, we're expecting the petitioner, because the law says he who alleges must prove. The petitioner has told us that he has 5 witnesses who will prove, among other things, that nobody got 50% and that we should go for a runoff. Not so. The petitioner has put 2 witnesses in the box who have been cross-examined. We are expecting that the petitioner ordinarily will call the other 3. The petitioner today brought an application which was filed just in the last 48 hours, which application is what has consumed our time. And our expectation is that the petitioner will either continue with the 3 other witnesses or inform the court that they intend to bring down their case at this point for the respondents to now also move whatever submissions that they may have. Intervening in these 2 is this new application that they brought, the chambers hearing, and the direction that we should come back on Friday. So we'll wait on Friday and hear what the court has to say.
Mr. Minister Designate, the petitioner spokespersons said that they don't have copies or carbon copies of this Form 13. May I know if you have one and why they don't have one?
So you should listen clearly to the court. You see, sometimes when we come to court, it's not what counsel on our side says or what counsel on the other side says, because lawyers and witnesses can say so many things. In the end, it is what the court finds. And if you heard the court clearly, the court started off by invoking CI 127 Rule 44, where copies are made available, and proceeds to say that the court is clear in its mind that all of those documents are available to the petitioner, and I dare even say by extension to all other parties who participated in this election in accordance with the law. That's been the very clear finding of the court and ruling accordingly.
Mr. Nkrumah, your side has always held from the very beginning that...
I'm sorry, I can't hear you very well.
I'm saying your side has held from the very beginning that the petitioner has no case. You have told us that they've gone through their witnesses, they finished with 2 of their witnesses who provided 2 witness statements. You also cited the High Court procedures of how when applicants make a case and they send witnesses through and they are done, what happens next? Will your side file a submission of no case on Friday or going forward?
Well, they have not, in our understanding, completed making their case. They have only called 2 out of 5 witnesses. The first one is the one who came in ostensibly to suggest that nobody got 50%. But you saw this witness always calculating and getting 47.51. The second one, who you thought was also coming to provide evidence that nobody got 50%, came in only to say that he heard through Rojo Metil-Nuno that they were instructed to leave, and later admitted that nobody had power to instruct them to leave. As to how that accounts for nobody won 50%, I'm not sure. They have 3 other witnesses that they have informed the court they want to call. So it is at the end of the making of what is ostensibly their case that respondents will take the next line of action.
Primarily, the court asked...
I'm sorry, I'm struggling to hear you, sir.
My right honorable, good afternoon. Primarily, the court asked for more details from the plaintiff, the complainant, that the case was adjourned to the 27th. Now, have the details, all the details been supplied? And is that the reason why there's an adjournment to Friday for a decision? And if all the details have not been supplied, is there a reason for an infraction for continuity at all in this case?
As I've mentioned, I cannot guess the purpose for the court's order of adjournment. We are in the hands of the court. We'll come back on Friday and hear whatever further directions they may have. I want to thank you. After one more question, and then I would invite my colleague to wrap up in 3.
Honorable, this morning, the lead counsel for the petitioner asked a question in court that if the EC's interest is in transparency, then why is this so difficult for them? Indeed, you have on several occasions spoken about the public opinion that the lead counsel for the petitioner appears to be pandering towards public opinion. But public opinion is also very important for clarity. If indeed there is nothing to hide, why are we using the law to prevent the EC from coming up to give sunshine to these matters?
Well, so the EC has already provided sunshine to these matters at the 38,000 polling stations in the country, at the 275 constituency collation centers, at the 16 regional collation centers, and then at the National Collation Center, and has made all those relevant documents in accordance with Rule 44 of CI 127 available to all parties. When you come to court beyond that and you want to invoke the discretionary jurisdiction of the Supreme Court to inspect the so-called originals, there is some legal standard you must meet. The legal standard is not the propaganda question of if you have nothing to hide, why don't you show me? It's not in the law. The law says that you have to show what we call necessity. Necessity to fairly dispose of the matter. And that if it is not done, the matter cannot be fairly disposed of. That you must show that there is necessity to reduce the cost of litigation. As you heard counsel for the petitioner argue, he was not able to satisfy that threshold. So, my dear brother, don't fall for the propaganda argument they make on the side. There's a legal threshold. As you hear them make the argument, for example, like I cited in the earlier one for application for supplementary, there's a legal threshold. You don't fail that one, cite wrong cases, cite wrong authority, and then now throw in a propaganda question that asks them that if they have nothing to hide, why? This is a court of law. So if the court and the law imposes a legal threshold that he who alleges must prove that you satisfy the concept of necessity, you recall in the case of interrogatories, it's not a propaganda argument, it's that why are they not allowing us to ask our question? Why are they not? No. The law says that the interrogatories must be relevant to the issues. So if you ask questions that are not relevant to the issue, you will not be allowed. You don't get to go around making the argument that why are they not allowing us to ask questions? No, the questions must meet the legal threshold. Thank you very much. My colleague would do the tree translation for us.
Abusanfo yabeda mo ase ene eye eda etoso enkono a yehia wo eye court dem ha nene ne yakoso yenyina yenim eye petitioner bibia no mo so mo onyina so omo evidence omo onyina so na eye openia sedun ketia a ono ebedi adanse eye ma former president Mahama na no oba betena adakam ye toto na no ye hu se ne nsem ne nyina no ensisi so enron so eye openi pesa white enso ebetena adakam eno so ye nyina ye hu ne ye ko ye se ne nsem ne nyina no atonsuom enti adansidi a omuni enti ene ye de krata ba beto court anim se eye krata omo ankasa omo wo bidada sanse emra no eye CI 127 no ehye isi keten se woto aba no polling station wie na se ye kenkan ye hwegu ho na ye de nyina no egu krata so a eye parties obibio take part bia na musini no eho behia se obenya krata ni bi ebiem se eba constituency nso a emra ne hye se krata na yabu nkunta aguso ne ya che obia ema onya ye no eno nso emra ne hye isi keten se obia party bia na musini no ebenya eno nso copy sa ena oba region so a etie ena oba national so a etie eye petitioner eba no wankasa nkratai onya bi onka ba bia sa da awo ne krata o de aba to court mu enne omo say 275 constituencies no yemfa ho krata nyina nyina ma omo isi emfa ma omo
Ebiem all the 16 regions no so no. Easy emfa ho nkrata nyina ma omo. Ansa na ye ba national so emfa ho nkrata nyina ema omo. Na abusuafo nea ehu hia ye pa ne se. Sankrata nyina so omo obi dada. Etiene yi se obehwa kasatintin wo hoi entoponko. Twene nso animu da ho a ye monche mu asempa wo hoi etia. Etinya kasatintin donhwere no ene nsɛm a wobɛka asɛbia yɛ ntwankyia no ɛna ɛno bɛka sɛ ɔwɔ asɛm etiene wohwɛ easy lawyer na wohwɛ ɛyɛ president Nana Akufo-Addo lawyer nsɛm a ɔmo kan na gyina mmara no so ɔmo se sankrata nyina ɔmo wɔ bi ina ebiem nso no ɔmo hu hia ɔmo ntimi enda na di sɛ hu be hia sɛ ɔwɔ sɛ wei no yɛde ma ɔmo ɛhɔ ɛna Supreme Court ɛkɔ ɛna ɔsa baaye mpanifo baaye ɔmo nyinaa mpanifo nso ne nyinaa adwen ɛkɔ benkrom ɛna ɔmo nyinaa se ɛyɛ saa nsɛm yi a mo se yɛmfa mo nam pɛ sɛ mo hwɛ nkrataa mu yi ne edi kan mo wɔ saa nkrataa ne bi dada ne ɛtɔ so mmienu ɛho hia no mo ntimi ɛnkyerɛɛ ne ɛtɔ so mmiɛnsa mo nsan ɛnka ɔmo petition ne mu sɛ nkrataa no mo nsan ka eti sɛ wokɔ ɛyɛ yɛmmra mu Evidence Act na ɛyɛ section 166 ɛda na di pefee sɛ krataa bia yɛbɛma wo ebie sɛ ne pɔtɔka sɛ meka no carbonized copy no saa krataa ne yɛde ma wa ne original no ɛne ne nyinaa no ɛyɛ pɛ a court agyi tum sɛ yɛ adanseɛ ɛno nti no court mpanimfo nso yi ɛbɔ ɛyɛ nsɛm no nyinaa eguyɛ abusua mamema ne nda na di sɛ ɛkamea kɔyɛ sɛ ɛyɛ petitioners ɛyɛ former president Mahama oni adanseɛ nti court dɛm hɔ anɔpɛ sɛ ɔde ne ti ɛbɔ bɔdan mu na ɔpa adanseɛ enti oni adanseɛ nti no nanu yɛbusaeɛ sɛ na mo ankasa mo yɛ mu coalition no ɛyɛ former president Mahama onya asɛe ɔpani asie do nketia sɛ my lord I have not brought that figure to court kyɛ sɛ saa nkuntabuo no mamfa ama court na wɔn nso president a wogyina mu no nso onya asɛe ɛno nso a onim na nanado deɛ nso onya asɛe ɛno nso a onim na total no nso a ɛyɛ sɛe ɛno nso a onim eti ɛnɛ asɛm a ekosiye no court abɔ ne nyina agu na asɛm baako esiye a na eniye nyan na ɔsɛ ka ho asɛm asɛm bi si na ɔpani chachu asɛm a ɔkan ne sɛ ɛyɛ judge pani paa no na asɛm a ɔkan no ɛyɛ completely irrelevant questions obusae no wei saa kasa twitwe ahantan kasa asɛ yɛpɛ sɛ yɛka na efu justice for no ɛboɔ no ɛyɛ adeɛ a ɛwɔ sɛ kasa tia ɛyɛ very unfortunate sɛ pani lawyer pani paa wonim de na wutimi ɛne judge pani ɛka saa asɛm ne firi wa no koraba ɛyɛ very unprofessional language a ɛwɔ sɛ yɛka eti wei ɛne nneɛma a ɛnɛ ɛkɔɔ so ɛwɔ Supreme Court a ɛwɔ sɛ yɛma mu nyinaa mu daadi abusuafo ɛbɛda mo ase na ansa na no mɛsrɛ san sɛ yɛne mpanimfoɔ ɛna ɛwɔ ha alɔyafoɔ mo tam akyi ɛnɛ chairman Makmenu emu wɔ ha Ɔbaapa Joyce enso wɔ ha lawyer Joyce Boateng enso ɛwɔ ha sei ɛna Hajia Fati Abubakar ɔno nso lawyer nipa deputy director office of the president lawyer Nana Adwoa Adobia Asante enso ɛwɔ ha sei ansa na ɛyɛ Evans Nimako ya lawyer mpanimfoɔ mu di anim ayɛ lawyer
Okay.
Using a computer.
And
I'm using a
computer na dey drawing. Na computer dey drawing.
Yeah, draw.
Person be na computer.
Oh yeah.
Photoshop na you.
Yeah, uhia. I'm on the computer with my phone say.
Me nya kura nti say ya kira wo.
Also dey no ye fi.
Computer so na.
Dem wo ye wo he won kan na wo he.
Takrade.
Na takrade he fa.
Takrade Technical University.
Okay.
Eti and what is e fi zebe?
Bachelor.
No one sabe cause
Inti if he fa kwata takrade.
If Kumasi.
Oh, okay. Na e ko e. Tipole. They were in
Takrade Technical
New
University.
site. The new site no.
Debbie.
No
Kalima.
Oh, okay.
For social media handles.
Bachelor engineer Yabo at Tiflos. And me can say Facebook and so a official TO Art Gallery.
Official TO Art Gallery and Facebook, you know. And Instagram near Yabo at Tiflos. Or contact be a man for betting me for us one.
Contact me 0248 814496.
Okay.
0248
814496.
Okay.
Valentine ya mondodro nipa fanko chiche ne adeatia. So de mti mondodro bi na na nya fan.
Like you know, me ye ada.
Yes so be frem.
Mama frem nto mbo sorry.
Me ye ada works so. Like anya digital no kwa.
Yeah, sound nobody.
Do painting, pencil work, pen work and a lot.
All right. Yadamasi Pao. Sunyane Takrade. What a combination.
Collaboni agree.
Great pa. Great pa. Chama yankwe.
Yes, I'm fancy but better catering service for them was a dance man. But on my refreshing. They be our session, but better. I'm more shitoni idea now. International over from an archer said. Na waje omo orders unso office ni ade na ohia nkrofo a ombe mane aduane e office lunch ni ade nyina no I don betimi e de abrawenti udi ane say obe send obe from our telephone so our telephone number from obenya 020-910-4748 020-910-4748 Babeta Kitchen.
Simentia Mrs. We are Femano GH AK West Hills. Mrs. We Africa so Tuba Junction and a pay area. It's your papa. There we are quando pizza there in an pizza.
Yeah.
From 0244284486. Yeah, oh, we didn't host sir. I don't quote to upon Temo and Yadiana.
Oh, sir.
And I pass over 40. Obama 40.
I will say upon and run Dr. Kakutin Bob Subose, Sunny of Adia Yao can wager I can so cotton a beja bosu.
Ayo.
Probably uncle, yo,
Chaman. You won't consider the friend. Amen. Catao.
Amen.
And a Korean Catabo, which is Chausha. Butu so. Don't show so. Butu so.
You were Butu so the bear.
Wouldn't you probably cry?
Don't see I was so massive. Yet we said, I'm patch out, extra cotton transit. Extra 10. Samebadia.
Aye.
Samebadia.
Na drive sakramai.
Samebadia. Yebe pon 10.
So one bad say yen na so yama.
Sacrament driver.
I tell you Sacrament driver.
Under the driver prem GH na so akopem Sacrament beba. Yeda masi.
GH boss Sacrament.
Westers, AK Westers.
Minim said dia. That's how the boss Sacrament be don koda. Ojem na so time nso yi.
Da omo ye
time nso.
Omo time nso yi.
Ya ye Prophet ba 30 minutes no. Prophet ba bon pa 30 minutes.
Me pesa me chese ensan. Time no nso yi.
No prophet can be na o hanka misal o ya santini ana. Ye wo kika bi tira mo pa o. O se asante for men man nim romance. No, one fin again, no. Obe friend na catch us, baby, my feel. As a quadro na, esi, Eh fa na wa nyumre no kwai.
I just walk pill. Oh, dia wa hima wa de be ma sisi ya.
Na hima e romance. Oh hima e romance. Oh hima e romance.
Me share
hima e romance
for hima nye hwe.
Concert party bi o say monke kan kwasa.
How many times I was Santini be ma? Friend darling. Street. How many percentage ni say?
Kwai do kra.
Santo for member ni darling.
Mankasim.
One after mama kambo.
Yeah, bu da fu ni kambo. Mo pesa mo wada.
Bacho, Asantini be ma be no na twempra.
Oh, I need some who be out.
Oh, yeah, Santini, Mr. Dusay.
Oh, yeah, Santini. No, you're Robert.
Oh, friend. Hello, I see a hair come at him.
Maybe any mass.
Monsters are going
for romantic.
There's your friend, Muno. Or friend, I'm saying, I say, why do you want to find you?
Monsters, hey.
Romantic.
Why romantic? Many nothing. So for me.
You may be Santo. Yeah,
hey.
Say madam na ye hand sanitizer just wash yes,